not to back any one of you in a corner or to expose any potential trade secrets of the United States law, which is commonly and accepted as normal practices by the general public. My goal in this exercise is twofold. One, to support and aid the United States for safe conduct and innocent passage due to its unsustainable national debt. To be clear, not my debt, but rather United States debt. I believe this is accomplished through a signature by accommodation to provide equity needed to extinguish and obliterate debt. However, with many attempts to various public officials from Pope Francis down to Judge Mark Spicer and just about every public official in between to provide aid to the United States, no person has responded. And two, by operation of law, my use of such condo property may be subject to paper terrorism by authorized public county officials should a person or a presumed trustee de suntort fail to discharge notice of ad valorem and non-ad valorem tax assessments based upon Lori's unsigned claim of assessment valuation. This bill notice is sent by the County of Broward Revenue Collector. Failure to discharge this claim, ultimately said condo property will be subjugated to various remedies under statute as outlined by Sharon Thorson. Sharon works for Broward County. She's an attorney. In a letter dated December 11, 2014. It would be me who suffers the consequence under duress, threat, and coercion, and not the fiction person, as I need shelter by necessity to have some quality of life. The main reason that I seek is truth from the Value Adjustment Board to find out when Lori uses U.S. currency and U.S. dollars to determine fair market value, how is it possible she does not too use Federal Reserve notes, as no other option is available in the United States? Does Lori's claim of tax assessment to compute a tax violate 31 USC 3124? Exhibit B. Please take note, again from the best of my understanding, the United States Code is prima facie evidence. Exhibit B is the actual 31 USC 3124. I attached that, I'm sorry. Please take note, again, that to the best of my understanding, the United States Code is the prima facie evidence of law, as some titles are enacted as positive law and others are not. The reference referring to United States Code is to make it easier for this Value Adjustment Board. However, statutes at large is the public law with the congressional intent, and the United States Code should be referenced back to the actual statutes at large. Again, I'm trying to make it easier for the Value Adjustment Board. I am attaching from the U.S. Treasury Department's website the following, as well as a bank manager's statement, Exhibit C and D. This information, I believe, provides evidence to the fact that the only currency that exists is in only one form, as Federal Reserve notes and not United States notes. And this has been the case since 1971. So just to bring this up, what I did was I went on to treasury.com. Let me just get that up, just so you can find it. And on the front page, just so you can easily get this, there at the top it says Resource Center. And then under that, towards the bottom, it says Frequently Asked Questions. And you go under there, when it pops up, on the right hand side it says Currency. And then towards the end, it says, at the end, it says Legal Tender Status. That's what you want as a reference. And this should give you some insight. I'm not going to read it now. That's something you can look up. But that's part of this. And then what happened, I have a friend who is a manager of a bank, and I asked him if he would be so kind as to give me a letter, which he signed, and the letter says, with bank stationery, that United States dollars, United States currency, or United States funds are synonymous as or to Federal Reserve notes. As United States notes serve no function that is not already adequately served by the Federal Reserve notes, their issuance was discontinued and none have been in place into circulation since January 21st, 1971. I'll get into why I'm bringing this up, and then there's a picture of what is a copy of a Federal Reserve note. The above is an image of U.S. currency, legal tender, U.S. dollar, U.S. funds, or money within the United States. And the reason why I did this is I had emailed Lori, and she, being a very smart politician, says she uses U.S. currency and U.S. dollars as her fair market value. But she would not admit she uses Federal Reserve notes. And again, under 31 USC 3124, it is prohibited that a state or political subdivision uses debt obligations of the United States in order to compute a tax. Again, you should have that in front of you, that statute. The banker goes on and says, I have been in banking since and have only seen Federal Reserve notes in the form of paper currency. Anytime a check is cashed, drawn on funds upon a bank, or money wired for any reason in the United States, the U.S. funds are in the form of Federal Reserve notes as U.S. dollars or U.S. currency. So going on with my narrative here, it is my opinion that Lori is a very smart and intelligent power broker politician. When specifically asked through email in early October 2015 what she uses in her assessment for fair market value of property, she did admit to U.S. currency and U.S. dollars, but smartly she answered she does not use Federal Reserve notes. How is it possible? Over these last 2 years, I have written to Bertha and Lori. Bertha is the county administrator, and Lori, of course, is the property appraiser. And here too attached are those correspondences. I have received typical lawyer responses from Sharon and Mila. Sharon Thorson is an attorney that works for the county, and Mila is an attorney, or I don't know if she still does, Mila Schwarzreich works for the property appraiser's office. You may take the time to go over this information. It is quite long, and I attached that as Exhibit E and F. After reading through this information, there is evidence to suggest that Lori does in fact use U.S. currency, U.S. dollars in the form of Federal Reserve notes in her fair market value tax assessment in order to compute a tax. Since gold and silver have been removed from the system, and I put in brackets, apparently without the authority to remove such, i.e., or for example, amendment to the U.S. Constitution, and apparently only Federal Reserve notes exist per Exhibits B and C, such computation of taxes with debt obligations of the United States appear to be prohibited under 31 USC 3124. To try and get my head around this, if, for example, Lori, as authorized by the Florida Constitution, could use coffee beans to assess the value of property within County of Broward, and I would guess then such property tax notice issued by County of Broward could be discharged with coffee beans. Logically, this would not violate 31 USC 3124. It is my understanding that when persons use Federal Reserve notes, nothing is paid for, as by definition, a note represents debt. Federal Reserve notes are debt obligations of the United States, and therefore everything purchased with Federal Reserve notes have an irrecusable first lien obligation upon it. This would include the people, titles, instruments, birth certificates, and what they believe to be their homes, car, bank accounts, etc. This too has been brought to light in the congressional record. And I do a direct quote. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property. And what do you think other property means, folks? That's right, your ass. Of all the people in the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. Anyway, that could be very upsetting. But again, I'm not mad, I'm not angry, I just want them to follow the law, their law that they have contracted by oath of office to follow. I'm continuing. The definition of Federal Reserve notes are debt obligations of the United States, can be found under your 12 United States Code 411 and 18 United States Code 8 as attached, Exhibit G and H. If I have misunderstood anything in this or previous correspondence with Bertha and Lori, I ask for your forgiveness, then your patience to correct me. Again, my goal is not to confront or even annoy any one of you, but rather to support the United States and all the future generations, including your children and grandchildren, so we or they do not wind up in a debtor's prison based upon private, worthless, dead paper credit that is backed by what we believe falsely to be our property. And falsely was put in brackets. Again, to get my head around this subject, a deed to property is a representation of, no, I didn't say representation, a representation of the actual real physical property. Should County of Broward start a legal process for failure of a person to discharge property taxes, such process could ultimately result with the loss of property shelter, then the real people suffer. It appears to be a legal fictional thing where real people accept the system, private as appearing public, because it's really a private system, because who owns those Federal Reserve notes? Well, yeah, you're getting it. To do a little bit of UCC, Uniform Commercial Code with the Value Adjustment Board, with the understanding as presented that I am a mere user of the name Anthony Rubio, where the state of New York holds original title and the United States is the beneficiary of such name and or property under a declared national state of emergency. All property vests with the state. I have accepted the offer to petition the Value Adjustment Board request for hearing before its tribunal. The Value Adjustment Board has the authority to accept such petition, counter, or reject. If the Value Adjustment Board accepts or counters the petition, fantastic. If the Value Adjustment Board rejects the petition, it does so with dishonor and accepts the fact that Lori acts outside her authorized official duties and violates Section 31 USC 3124. So here it's a little uniform commercial code with them. Excuse me. In summary, I'm continuing. Number one, accept such property tax assessment does violate 31 USC 3124 and remove the property from your tax rolls. Should you still require money or whatever, you have attached a usufruct compliant certified certificate that under international and domestic law is supposed to discharge and acquit all obligations under the rule of usufruct. Matter is closed. Send confirmation. Our business is complete. Number two, counter and correct my error. If I am incorrect, and Lori does have the authority to assess property taxes based upon federal fair market value, where such fair market value is based upon transfers of property where the purchase price of such property located within a political subdivision of the state, United States has been paid for, I believe a more accurate word is discharged of an obligation with the use of legal tender, that's in brackets, in U.S. currency or dollars in the sole form that currently exists in the United States as Federal Reserve notes, in order to compute a tax through the use of a millage rate, please have Lori Parrish as property appraiser sign, and this is in brackets, original wet ink signature, and brackets, her claim in the presence of a notary public with notary seal affixed to notice under penalties of perjury in Lori's official capacity that she is authorized by law to compute a tax using U.S. currency dollars in the form of Federal Reserve notes, as no other form of U.S. currency or U.S. dollars is available to make her claim of property tax assessment in order to compute a tax. This is attached. Mail back to me. Please forgive my misunderstanding of your statute. Lori's claim for tax assessment thus is in accordance to all statutory law. Matter is closed before the Value Adjustment Board Tribunal. Using common sense in order to file this petition, one must sign this is cute. Using common sense in order to file this petition, one must sign claim form DR 486. Yet it seems so strange that Lori is not required to sign, even if a copy of her signature is used, each tax assessment claim as being lawful and accurate. What's up with that? And then in brackets, presumed consent or consequences, I imagine. Then number 3, reject or ignore. Go into dishonor under admiralty, under rules of war on land. I believe you are able to ignore this matter, at least up to a point. Regardless, failure to respond honestly, adequately, and completely to this matter, to correct a possible error on my part, will result in your intentional, knowing, and voluntary assent to my assertion that Lori is in violation of 31 USC 3124. Is it all con upon the public for the personal profit and gain of public officials? I do not mean to sound sarcastic. I'm just not sure how to word the matter simply and accurately. I can see from your form, DR 486 form, there is tricky legal language in there that this is why I wanted to correct any false presumptions. When I have learned that everything in law is about presumption, threat, persuasion, misrepresentation, and out deceptive fraud through force, I assume this is why Lori cannot sign her claim for tax assessment. This can easily be disproved with an original wedding signed tax assessment with Lori Parrish's signature, as I have attached for her convenience. Since Lori uses the mail system to send out her claim for tax assessment, this possibly would violate your 18 USC 1341, and then I put that as Exhibit I. To be very clear, I'm not angry, resentful, trying to pull fast when looking to annoy anyone, to outsmart anyone. My goal is to wake people up to the legal fact we are choosing private credit to destroy ourselves. All I'm trying to do is stop this insanity before it is too late. Too late equals Greece, Cyprus, Central and South America, Ireland, Italy, loss of US dollar as the world reserve currency. Do you understand? Do you really get it? Do persons really not care about the future persons and their well-being? Excuse me. In a statement Jefferson made in a letter to John Taylor in 1816, he wrote, "And I sincerely believe with you that banking establishments are more dangerous than standing armies, and that the principle of spending money to be paid by posterity under the name of funding is but swindling futurity on a large scale." End quote. Upon my departure from this planet, I want to make sure I have done everything reasonably to ensure I have leave this planet a bit better than I found it. I ask of this board to do the same. The cash check made payable to Broward County Value Adjustment